Hi. So to win a court case, the technique is we have to inform truth to the court. So before informing truth to the court and why we don't inform truth to the court, we must understand what happens in the court. Now there are 5 levels of courts that are available all over India. There will be junior courts, there will be senior courts, junior civil courts, senior civil courts, district courts, High Court and Supreme Court. But to enter into High Court and Supreme Court, the question should be deep. The deeper question is called substantial question of law. Under Civil Procedure Code, Section 100 speaks about substantial question of law. So before understanding what is substantial question of law, we must understand what is a question of law and a question of fact. Whenever you file a case in the court, the first court will be the trial court. Trial court means you bring facts to the court, you inform facts to the court, bring evidence to the court. So whether the fact is existing or not will be decided based on the evidence you bring to the court, and law will be applied to the fact after it is established that it existed. So this is what happens in the trial court. So trial court decides questions of facts. That is to say whether the fact existed or not, and if it existed, based on the evidence, application of the law. After that, trial court decides the case. Case is complete in the trial court. Always remember that trial court is as important as Supreme Court. Because after crossing trial court, only the material which is in the hands of a judge is adjudicated. In the trial court, material can come from outside the court. To decide a fact, evidence has to come from outside the court. And after crossing the trial court, you enter the appellate courts, which will be senior district courts, high courts, supreme courts. There the question of law is decided. To be more precise, substantial question of law will be decided in High Court and Supreme Court only. But to enter High Court and Supreme Court, it is mandatory in civil trial to have a substantial question of law. And how will a substantial question of law arise? If you want your case to be seen by High Court judges and Supreme Court judges who can look deep into the case because they are seniors, then your case should have substantial question of law. And if you want your case to have a substantial question of law, you should inform truth to the court at the trial court stage. If you don't inform truth to the trial court, it will be a regular case. And regular cases, already there are established principles since past 70 years. So therefore, courts decide very quickly and you don't have the chance to enter the higher courts. I will tell you an example, which is in the description box. You can go through that. A recent decision of the Supreme Court where High Court created a wrong substantial question of law and Supreme Court set aside that order, confirming the order of the first appellate court. The plaintiff, that is who filed the case, filed a case claiming that the defendant, that is against whom the case is filed, is a tenant of the property owned by the plaintiff. But he failed to prove the rental agreement, office copies of the rental receipts, property tax receipts. Therefore, the trial court dismissed the case of the plaintiff. So obviously, when the case of the plaintiff is dismissed, he comes to the appellate court. He came to the appellate court. Appellate court, after examining the facts, evidence, application of the law, came to a decision that plaintiff owns 50%, defendant owns 50% of the property, and confirmed the title of the plaintiff, refused to give possession of the plaintiff's property because plaintiff was not in possession since 50 years. Defendant was in possession since 50 years. So possessory rights were given to defendant, title rights were given to defendant, and title rights were given to plaintiff. 50% title right with the plaintiff, 50% title right with the defendant, and possessory right of the entire property, that is the property that is owned even by the plaintiff, to the defendant only. Why? Because the evidence supported those facts. Therefore, First Appellate Court confirmed the case like that. Aggrieved, both parties went to High Court for appeal. Now the case was closed at the First Appellate Court itself. Why? Because plaintiff came to court with unclean hands. Plaintiff did not inform truth to the court. Plaintiff wrongly pleaded that defendant was a tenant, which is wrong. Therefore, he could not prove it. Therefore, there was no opportunity for any substantial question of law, and High Court fell into error, creating a wrong substantial question of law, which was set aside by the Honorable Supreme Court. So, if you want to win a case, you have to be truthful. That is the point. And what is a substantial question of law? Substantial question of law will have two opinions, which will have a larger public interest. It is a question of law with a qualification, that is substantial. When you inform truth to the court, then only substantial question of law will be born. Remember this, because every case is different case. No two cases are similar. Because you don't inform facts to the court properly, all cases appear to be similar. Otherwise, every case is similar. How could two cases be similar? The facts and circumstances of each and every case are different. But the subtle, deeper points, if need to be examined by the Honorable High Court and the Supreme Court, you have to inform truth to the court at the trial stage. Then only substantial questions of law are created, and your case will be examined by the higher courts. Okay, hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.